Welcome to today's webinar, everyone. Best Practices for Harassment Prevention. I'm Anna Hobson from hrsimple, and I just have a few announcements before we get started today. Today's webinar is in partnership with Constangy. If you do have any questions for Robin, we will get to them throughout the webinar. Just go ahead and enter them in the question box, and we will get to those throughout the presentation. If you would like to watch more webinars or watch the recorded version of this webinar, you can go to hrsimple.com/events. We also post webinars from credible sources like Constangy. I will be sending out a recording of the webinar along with the slides within 24 hours, so be checking your inbox for that. hrsimple provides federal and state-specific manuals written by top labor attorneys. Vacation policies, COVID-19 in the workplace, and how to fill out the I-9 form are just a few of the topics the manuals cover. You can view these credible resources at hrsimple.com. Before we get started, I just wanted to go over Robin's bio. Robin has 30 years experience in employment litigation. She provides preventative advice to employers and conducts training for HR professionals, management, and employees on a wide variety of topics. She's also editor-in-chief of Constangy's legal bulletins and its 3 law blogs, Affirmative Action Alert, California Snapshot, and Employment and Labor Insider. She also produces Constangy TV's Close Up on Workplace Law. She's also written a couple blogs for us, so I would highly recommend to check those out at hrsimple.com/blog. So on that note, I'm going to go ahead and hand things over to Robin so we can go ahead and get started.
Okay, can everybody see that?
It looks good. I think if you hit display settings and then slot presenter at the top, it will full screen.
I couldn't understand what you said.
If you hit display settings at the top,
oh,
it will
okay.
full screen the presentation. Yes, there you go.
Okay, thank you.
Perfect. It looks great.
So we're good? Okay.
Yeah.
Hi, everybody. Thank you for joining us today. We're going to talk about harassment best practices, how to handle harassment claims. And I think a lot of employers are probably a little rusty on this because many of us have been shut in for a year and a half. And that really reduces the chances of harassment. It's still possible to harass somebody over a Zoom conference or something like that, but it's going to be a lot easier to get back to mischief now that people are coming back into offices in person again. So we'll talk about some of the things that employers should be doing to prevent harassment claims and also to address them appropriately. And we've got a little bonus session at the end about some of the special precautions that I think employers need to take post-pandemic in our current world, which is a little bit different from what we were advising 2 years ago. So as Anna said, feel free to ask questions at any time. You don't have to wait till I'm at the end of a slide or at the end of a section. Just go ahead and send any questions you have to her, and she will read them off to me, and hopefully we can get everything answered that you might have. Why we care about all of this, of course, as most employers know, harassment claims are difficult to defend. They have often very complicated facts, which requires a lot of witness interviews, review of other types of evidence to determine whether the harassment actually took place, how severe it was, etc. And if any of you are following now the allegations against Governor Cuomo in New York, the report that the law firm put together on his allegations, which were made by, I believe, 11 women, is 168 pages long without exhibits. And then I think there's something like 400 pages worth of exhibits that law firm reviewed, and single space too, I should add. So the facts are often very complex, and that makes them harder to defend and also expensive to defend, which is the next point. They're almost always expensive for employers because you do have so much factual detail you have to dig into, and a lot of times it may be one employee's word against the alleged harasser, or there may be multiple claims against one person, which requires a great deal of time and a great deal, unfortunately, of billable attorney time. Again, now that the pandemic is easing up, as workers get back together in person, we do expect to see a boomlet, at least, if not a boom, in harassment claims, just because people have been separated for so long and they're back together. And it's possible people will be a little overly enthusiastic when they get back together, which could result in more harassment claims. So having your ducks in a row at the very beginning will help you avoid claims and also help you do the right thing when you do get a claim, so that the liability to your company will be at a minimum. So we're just going to go through best practices, and I'll be happy to talk about anything, any questions you have related to each one of these. Number one, if you don't already have it, make sure your harassment policy is in plain language. You should use regular words that people normally use. Avoid legalese. Avoid quoting the Supreme Court definition of hostile work environment harassment. And just use plain language and use examples that people can relate to in their everyday lives. Telling a joke that has a sexual component to it, telling a racial or ethnic joke at work, that type of thing. If you give examples like that in your policy, it'll make it much easier for the employees to, first off, read the policy and not tune out. Second, to understand, oh, okay, this is the type of thing I shouldn't be doing, or if somebody's doing it to them, this is what the company means by harassment, and so I need to look into how to make a complaint. Also, if you have a multilingual workforce, make sure that policy is published in the languages that your employees are fluent in. If it's English, Spanish, that's usually really easy to do, but a lot of workplaces are more diverse than that and may have people who speak Vietnamese or other types of languages. Just make sure that policy is available to employees in the languages they speak, so they understand how they should conduct themselves at work, and also will understand when they're a victim of harassment.
Robin, we did just have a question come in.
Oh, great. Okay.
It says, is there a statute of limitations on workplace sexual harassment claims?
Oh, could the person asking that give us their state, what state they're in?
Georgia.
Georgia, okay. I'm not sure what the Georgia statute of limitations would be. It might be, I'm guessing it, this is a guess because I'm in North Carolina, it would be 3 years probably under state law. Under federal law, and this would apply to everybody if the employee is asserting a federal claim of sexual harassment, you have to file a charge with the Equal Employment Opportunity Commission. Depending on the state you're in, I believe in Georgia it would be within 180 days or 6 months from the last harassing act. That would be the case in North Carolina as well. In other states that have their own human rights agencies, it would be 300 days, so almost a year from the last harassing act. And you file that charge, the EEOC or the state agency, presumably will do an investigation. they'll make their determination, and the agency can either file suit against the company, or they can issue what's called a right to sue letter to the person making the allegation. And if they do that, the person making the allegation has 90 days from receipt of that letter to file a lawsuit in federal court. Kind of complicated. I'm sorry about that. Generally, most people are using federal law to file harassment claims, except maybe in states like California, which have much more employee-friendly state laws. And so most of the time, as an employer, you can count on that 180-day to 300-day statute of limitations to file a charge. Of course, there's no telling how long the charge is going to sit there at the agency before a right to sue letter is issued. So it can still be a long time before the employee's deadline kicks into place. Anything else? Okay, so that's number one.
Thank you.
Okay. Number two, conduct training on a regular basis. And if you're like most employers right now, you may be behind on your training only because you haven't had anybody in the workplace for a while. So do check on that. It should be conducted on a regular basis. And in normal times, my recommendation is do it about once a year. Management definitely should get training at least once a year on harassment, and we'll talk some as we go along about why that's so important. But I also think it's important for employees to get training, non-management employees, because they need to understand what kind of behavior can get them in trouble, and they also need to understand, what do I do if I'm a victim of harassment in the workplace? And if you have regular training, that's the best way to make sure everybody understands what they're supposed to be doing. The other nice thing about having regular training is it really does win you brownie points with the EEOC and other agencies who enforce these laws. If you conduct regular training on harassment and you're unfortunate enough to get a claim, the fact that you had that training and that it's relatively fresh and hopefully high quality too, which we'll talk about in a minute, will help you defend yourself in that claim. Ideally, and this is a recommendation from the EEOC, the training should be interactive if possible, and that can include having a live person come do the training and the audience is able to ask questions and express their opinions about things. If you can't do that, or you may have, depending on what kind of a business you're in, you may have one or two employees scattered all over the United States. Interactive computer training is another good alternative because it requires the employee to do something to indicate they're paying attention to the training, and it doesn't require people to get together in a central location for training. So that's another good alternative. Probably the least ideal of the options would be to have it by, having the employees watch a video or something like that where there's no interaction going on at all. Although I must say there have been some videos, some training videos that have been very good, and sometimes they're entertaining enough that you think people would probably prefer this to a computer program. The training should be appropriate to the audience. For managers and supervisors, I would recommend at least 2 hours and sometimes a little more than that, maybe 2.5. Employees don't need nearly that much time, and they'll probably start getting bored if you go on too long. So for employees who are not in management roles, I would suggest roughly 45 minutes or so for that training. And I would say I've had some clients who were shut down during the pandemic, and they're bringing people back, and they really do seem to be trying to catch up on the training that they missed during the time that everybody was remote. So this is a good time to get that done if you are able. What rank and file non-management employees need to know in their harassment training? They need to know what kind of behavior is going to get me in trouble. what's going to get me fired, what's going to cause me to be disciplined. They need to understand that they have the right to be in a workplace that's free from harassing behavior. They need to know how to make an internal complaint of harassment and to whom. So even if you don't want to designate a specific individual, you can at least designate a department like the HR department. Go there. They need to know what to do. And they need to understand that they will not be retaliated against for making a good faith harassment complaint. Good faith sounds like I'm leaving a big loophole there, but they need to understand that this really isn't a loophole, because we're going to assume that any complaint an employee makes is made in good faith. In other words, they had an honest belief that something inappropriate was going on or might have been going on. Even if they turn out to be wrong. And the only time we would recommend considering somebody to be making a complaint in bad faith is if we catch them red-handed saying, my manager wrote me up yesterday, I'm going to falsely accuse him of sexual harassment. It would have to be about that strong for us to say it was a bad faith complaint. And that's kind of a tricky point. Does anybody have any questions or comments about that before I go on?
I don't have anything yet.
Okay. All right. Now, supervisors and managers need to know everything that the rank and file employees need to know. What harassment is, how to make a complaint, that we do not condone harassment in the workplace. But in addition to all those things, they need to know what to do if they get a complaint of harassment, or if they observe a situation in their department that doesn't look right to them. They need to know what to do when that happens. So that is why the management training is going to be a lot longer. They also need to understand that they cannot retaliate against an employee who makes a good faith complaint of harassment. And that's true even if the complaint is against them individually. So they need to really understand all that. That's why that management training takes 2.5 hours and the employee training takes only 45 minutes. Because we usually have a lot of discussion about what do we do? What if we see something? What if somebody just makes a casual comment about an inappropriate thing that a coworker said? They're not even really complaining, they're just referencing it. What do we do? The training ought to cover all those topics so that managers feel very comfortable dealing with harassment issues as they come to their attention. And the other thing and this is another EEOC recommendation, and I think it's a good one, supervisors and managers should understand that the policy is endorsed by senior leadership and it is a priority for the employer. If the CEO or president can actually come in and make a couple of introductory remarks before the training begins, I think that's great, because people will really take it seriously if they hear that. If that's not possible, it may be possible to get somebody, the most senior person at the facility to do the introduction and stay for the session. I think that's important too. And they may have to do it for more than one. If they're live sessions, they may have to, unfortunately, sit through several harassment training sessions. But I think that sends such a good message to employees that this really is something we're serious about. We're not fooling around here. Best practice number 3 is an accessible complaint procedure. And what we mean by that, way back in the old days when I first started practicing law, harassment policy, and harassment was kind of a new legal concept when I started practicing. Policies would say, if you feel like you're being harassed at work, tell your supervisor. And that wasn't really a very good way to handle it, because what if the supervisor was the one doing the harassing? And the policy just says go to the supervisor. So what we've done, over the years as we're learning about harassment claims, is give employees multiple avenues to make complaints. Yeah, sure, going to your supervisor is great. If you have a good relationship with your supervisor, then that's probably the best place to go if you feel you're being harassed. But maybe you don't have a really good rapport with your supervisor, or maybe the supervisor is one of the harassers, or you feel like he or she is complicit in what's going on. In that case, people ought to be able to go to HR with a complaint, and there may be other places. They may be able to bypass the supervisor and go directly to their department head. Years ago, we started recommending that employers tell employees you can go to any member of management in this company, and they will make sure the complaint goes to the right place. And of course, we cover that in the management and supervisory training so that they all know, okay, if I get this, what do I do? They know to take it to the right spot. So make it as easy as possible for employees to make complaints if they feel they're being harassed in the workplace. And one thing we learned with Me Too a few years ago is companies also need to have a way to let employees make harassment complaints when the person doing the harassing or the alleged harasser is very high up, maybe a CEO, maybe a very high a senior vice president, or it may be what we also see is extremely talented people. Their title may not be quite that lofty, but they have certain skills or talents that are almost irreplaceable, which means the company isn't going to want to terminate them. Employees need to have a place to go if harassment is coming from somebody like that. And again, I'm picking on Governor Cuomo again. I shouldn't probably, but he's the governor of the state of New York. Who else are you going to go to if you feel like you're being harassed? The president of the United States? Who knows? So you need some type of independent person who can receive those complaints. And since we've been making that recommendation to employers, some solutions they're coming up with is, if they have a board member who's very sophisticated, maybe it's a lawyer or a human resources person who's very sophisticated about harassment law and what an employer's obligations are. It may be possible, if the CEO is the alleged harasser, it may be possible to take that complaint to a designated member of the board of directors. That needs to be in your policy so that employees know that that's where they should go if it's somebody very high up in the organization or somebody with irreplaceable talent. Another solution people have come up with is they have just designated an outside third party to receive that type of complaint, and they put that person's name and contact information on the policy. So that could be a law firm or an HR consultant, somebody like that who's outside the company entirely. And employees, if they are being harassed from somebody high level, can go to that individual, report the complaint, and then an investigation can take place, hopefully by people who aren't afraid they're going to get fired if they don't pull their punches. Practice number 4 is have disinterested, unbiased investigators who know what they're doing. And we want somebody investigating the complaint to have the authority to let the chips fall, to do a fair investigation. If it turns out the CEO is harassing somebody, then we want an investigator who isn't going to be afraid that there could be adverse consequences for them if they tell the truth. So ideally, if it's a lower level member of management who's the alleged harasser, like a supervisor or a manager, that should be pretty easy to do. You can get, somebody maybe at the director level, hopefully in human resources or in-house counsel, to conduct the investigation. They would outrank the person who's accused, so they would have the authority to let the facts go where they may. The other possibility is to have somebody who's completely independent. And again, I'd say, maybe an outside law firm or an HR consultant who's not part of the company. And if they're independent, it'll be much easier for them to just follow the leads where they go, find whatever facts are appropriate, and not be worrying about their career security, their job security, depending on what they find. So that's very important. And then next, the investigator ideally should not already know the parties. It's nice, in a big company that's pretty easy to do. In small companies it can be very difficult. But what we would prefer ideally would be an investigator who didn't know anybody before they got into this investigation. Had no relationship prior with the accuser or the accused or with any of at least the key witnesses. And again, that's just a way of making sure that that person doesn't have preconceived notions that might influence the outcome of the investigation. In a small company, of course, that may not be possible. Maybe everybody knows everybody, and that's a time when you might want to look at possibly bringing in an outside third party to conduct the investigation, or if somebody high up enough can do it, maybe get somebody at least who's high up enough that they can feel free to be fair and objective. The next one is extremely important too. The investigator should know how to conduct an investigation. This is not something anybody can do. It's difficult. Years ago, I had a harassment case. A woman had made some accusations that her lead person had sexually harassed her. And she reported those allegations to the department manager who was over both her and the lead person. Well, the department manager went back to the lead person and said, "Did you do this stuff?" And he said, "No, I'm not crazy." And that was the end of the investigation. And the department manager found that no harassment took place. That is an extreme example, even though it's a true story, that is an extreme example of a very poor investigation. No follow-up, no nothing, just taking the guy's word for it. And it turned out, of course, our client got sued. We ended up spending a lot of time digging into the facts. And although the accuser was not perfect, neither was the accused person. So there was a lot more to it than the department manager's investigation would have led us to believe. And again, if you don't have anybody in-house who has the expertise or who has the lack of bias to be able to conduct a good investigation, then consider going outside. There are lots of independent human resources consultants who do very good work, and they might be less expensive than going to an outside law firm, but of course going to an outside law firm is another option. So just make sure it's somebody who knows what they're doing and they're not biased. Number 5, an investigative process. Oh, excuse me. Let's see. Okay, an investigative process that's fair to the accuser and the accused. We hear the slogan, "Believe all women." That's okay to some extent, but that's really not a good philosophy to have if you are doing a harassment investigation. I cannot tell you the number of times we've done investigations and found that the person making the accusation may have had ulterior motives, and many of you may have been in that boat as well. A lot of times what we'll find, and this is probably the most common scenario when there actually wasn't harassment going on, the accused harasser and the accuser were actually in an extramarital affair. It broke up. Usually it's the he decides he wants to stay with his wife and his family, so he breaks up. She's hurt. She may have already left her husband, and so she accuses him of sexual harassment using the things they did when they had a consensual relationship going on. That is more common than I would like to have to admit, but it really is a fairly common scenario. So you can usually get at that, and if, again, I'm using the term man, it could be the other way around, but in my experience, it's usually the man who's accused of harassment after a scenario like that. If he will fess up quickly to the affair and share whatever proof he has that there was a consensual relationship going on, then it's not that hard to find out that there was no actual harassment taking place, that it was, things he did in the context of the consensual relationship are being used against him as evidence of sexual harassment. Other things that can happen is you might have two people who were buddies and they used to talk about everything together and they had a falling out. And then, for whatever reason, one party to the friendship starts using comments that were not offensive at the time and suddenly become offensive after the fact. There can be other ulterior motives. I talked about a supervisor who was getting ready to discipline an employee. That is not unheard of either, that sometimes the employee, may know she's in trouble, her job is in jeopardy for legitimate performance-related reasons or disciplinary reasons, and to protect her job, she will accuse the supervisor of sexual harassment or some other type of harassment. So I'm not saying don't believe all women, definitely not, because many times the complaints are legitimate, but do be a little skeptical and don't just automatically assume that if a man is accused of sexual harassment that, it must have happened. These false claims occur more often than you'd think. Once the investigation is over, either you as an HR person or maybe with the help of your in-house counsel or others, you have to determine what happened to the best of your ability. You may or may not be able to do that. You may not be able to definitively know whether harassment had actually taken place. But some of the things I would look at is, were there witnesses? Were there emails or text messages that indicate, that would push you one direction or the other? Was there any other evidence that would cause you to go one way or the other? And who was more credible? You usually want to save that till the end. But when you're done with reviewing all the other evidence that's been gathered during the investigation, you can look at how credible the accuser and the accused were during their interviews, or based on whether things that they told you were corroborated by other witnesses or by other types of evidence. And so you're sort of really making your best guess as to what actually happened, unless the accused person just admits to it right off the bat, in which case you don't even have to do an investigation. But otherwise, you're really doing the best you can. And fortunately for employers, the legal standard doesn't require you to find the accused person guilty beyond a reasonable doubt, as long as you have a reasonable basis for believing that the policy was violated, and you take appropriate action based on that belief, you are going to be okay legally. And I'm not going to say you won't get sued, because people can sue you about anything, but you should win eventually. figure out what you're going to do about it and be fair. You may conclude when the investigation is over that no harassment occurred at all. Maybe somebody made an inappropriate comment, but it's not really an unlawful harassing type of comment. Or maybe there really is just no evidence at all that any inappropriate behavior occurred. You may also find that there was a violation of your policy, and most employer harassment policies are pretty strict. So it would be easy to find that somebody violated the policy, but maybe it wasn't a severe violation. For example, maybe an employee who's been with you a long time, has a good record, told a dirty joke to the wrong person one day. That is a violation of the policy, absolutely, and I do think they should get formal discipline over that. But I think firing them would be a little harsh under those circumstances. So, it may be a violation of the policy that can be dealt with through counseling or through lesser disciplinary action. Or you may find that the harassment occurred and termination really is the appropriate remedy for it. And then we come to the one I hate the most, the he said, she said. If you think you have a he said, she said, make sure you really do. Don't just, if the accuser tells you one thing and the accused denies it, yes, that's a he said, she said, but that isn't the end of the investigation. You should try to talk to witnesses if you think there were any witnesses, and you should follow up with witnesses identified by the accuser as well as the witnesses identified by the accused party. Review all other relevant evidence, again, because that may sway you in one direction or the other. And I would confer with legal counsel, and you may have in-house attorneys and you can talk to them, or if you have outside employment lawyers, you can talk to them and just go over everything with them to make sure you didn't miss something before making a determination. Because people who do this all the time will possibly have suggestions of things you could follow up on to get a little closer to deciding who's telling the truth. So I think that's a good idea when you've got, somebody makes an accusation, the other person vehemently denies it, and you've got to figure out who's telling the truth. But one thing I would say is if you follow all your leads, you still can't figure out who's telling the truth, there's no corroborating evidence one way or the other, it's okay to say that the investigation is inconclusive. And if you do that, just let both parties know, the accuser and the accused, that you were not able to determine whether any harassment occurred, and thank them for cooperating in the investigation, and let the accuser know that if anything happens in the future, to please be back in touch and we'll look into that as well. Okay, best practice number 8. At least in my experience with harassment investigations and also defending employers in harassment lawsuits, there is always room for improvement. So when the investigation is over, or when the case settles, or the court grants summary judgment, I hope, to your side, it's always a good idea to look back and see what could we have done better? What could we have done that might have prevented this from happening altogether? And usually there are some things that could be done better. I think I can't even think of a case where we didn't have that happen. So some of the things you might want to look at is, were our existing policies adequate? Should they be adapted or updated? Maybe they're out of date. Do the employees need to have more training on how to behave in the workplace? Do any of our practices need to be changed? does our, are our harassment reporting options adequate? There are all kinds of things you can look at, and maybe everything was perfect and you just got really unlucky, but we usually do find that there are some things that could be improved. And then once you find those things, go ahead and make the changes right away, because it's best to do this while it's fresh in your mind. You're going to move on. Everybody's going to forget about it. And 2 years later, you'll get a harassment claim again, and you'll still have all these old policies in place that you should have fixed years before. So go ahead and do it while it's all still fresh in your mind, and do whatever you need to do to adapt your policies, and of course in consultation with your employment counsel. Follow up. This is number 9. Put it on your calendar. And what I mean here is follow up with the accuser. Especially if there was an inconclusive resolution, or if there was a resolution short of termination of the alleged harasser, and maybe they're still working together. Just go ahead and mark on your calendar for the next couple of years, I would say, every couple of months, check in with the accuser and ask whether everything's all right. Any concerns that I'm going to say she, because the accuser usually is a she, but any concerns that he or she needs to bring to your attention, and document the answers you get. And that will help you defend against a claim if anything else happens later on. So, and again, it's one of those things that will also win you brownie points with the EEOC or with agencies or juries or courts, that you cared enough to follow up. And it's probably going to also mean a lot to the employee who made the complaint that you're doing that. If you don't put it, the reason I say put it on your calendar is because if you don't, time will get away from you. We all know how that works. At least that's the way it is for me. If I just thought to myself, oh, I need to follow up with her 2 months from now, if I didn't put that down on my calendar, I'd probably never do it. And 2 years later, I'd be thinking, well, no, I never did follow up with that person about how things were going. So it's easiest to just put it on the calendar at certain intervals every couple of months, I would say. And that way you won't forget to do it. Okay, what are some new best practices for the times we live in now? I'll talk about these, and then if anybody has questions based on anything we've talked about today, I'll be happy to stay as long as you want to answer them. Number one, if you are doing an investigation yourself and you're having to do this by Zoom or some other video conferencing product, or by telephone, make sure that the people you're talking to are not recording the interview, and make sure they're not, this really happens, hiding somebody in the room or in the next room who's listening in and taking notes, because they can hear everything that's going on. Now, they could lie to you and tell you nobody's here, I'm all by myself, and they could still have somebody there and you'll never know. But if you get them to certify that over the call, I think it probably will have a chilling effect on that type of secret activity in most cases. The other thing, and I should have put this on the slide and didn't, but if you are going to record the interview, be sure you tell the person you're doing it. If you're in a state where you have to ask for permission and have that on the recording, and have the person grant the permission on the recording before you start asking any questions. And even if you're in a state like mine, where in North Carolina, we have one-party consent, so I could call somebody and record a conversation without telling them anything. That's legal. But as an employer, I think it's better to hold yourself to a higher standard. So even in a state like mine, I would recommend that the employer get the employee's permission for recording the interview and get it on the recording and then proceed with the interview. If you're in a state that doesn't have one party recording, where both parties have to consent, you're actually probably committing a criminal violation by doing a one-sided recording without consent. This is one that I have, oh my gosh, text messages are the greatest things in the world. I thought they were going to be bad for employers, but so far, they could be bad for employers, but so far the ones I'm finding are so helpful to employers. So don't forget to ask for text messages. There are apps available that can let you dump your text messages into a nice little tidy file, or you can just take screenshots from your cell phone. We had a harassment case where a woman accused her manager of sending her a photo through a text message of his private parts, or should I say private part. Anyway, he did that. We got a copy of it from her lawyer. It was very clear what that picture was of. We asked the manager. The manager said, yes, that's me. I admit it. And then he said, but look at the stuff she sent me. And he sent us his text messages, which were much more complete and not selective like hers was. And she had actually sent him videos of herself in very obscene poses. So, if you don't think to ask about text messages, you may miss that kind of thing. It's very helpful in determining who's telling the truth and who isn't. The other thing, in other cases, you may have some people just saying the boss made inappropriate comments, and you get the text messages, and the two of them are going at it all the time, very mutual, very friendly. Nobody's expressing any concern about anything. And, of course, if people were just talking to each other in person, you would never have that kind of evidence. But the pandemic has really helped us in that regard, because people were having to communicate via text and email a lot of the time. And those texts have saved a couple of accused individuals in harassment cases. So don't ever forget that. And they're much better than email, because people are generally more professional, I think, now in their email communications. But with the text messages, anything goes. And people have not caught on to the fact yet that they need to be careful about what they say in text as well, especially with people they work with. Also, hopefully everybody's already done this, but number 3 is, if you haven't already done so, update your harassment and EEO policies to include sexual orientation and gender identity. In the summer of 2020, I think, 2019 or 2020, the United States Supreme Court decided that sexual orientation, discrimination, and harassment, and gender identity discrimination and harassment are forms of sex discrimination or sexual harassment in violation of Title VII, which is the federal law that prohibits discrimination and harassment. So if you haven't already done it, when you're listing the protected categories in your policy, make sure they do include sexual orientation and gender identity, and do take those complaints seriously too if you see that going on. For example, if you have a transgender employee who's being harassed by coworkers because of their transgender status, by all means follow up with that just as urgently and seriously as you would if a biological woman claimed that a biological male supervisor was harassing her. And then finally, be aware of the law in your state. Georgia and North Carolina are pretty loose, and we pretty much just follow what the federal law says. But other states like California have adopted standards for finding workplace harassment that are more and sometimes much more victim friendly than federal law. So watch out for that if you have operations in those other jurisdictions or if you're based in those jurisdictions. It may be more important to be worrying about complying with your state law than it is to worry about federal law. Because if you're in compliance with your state's law, you'll automatically be over compliant with federal law, which is probably a good thing. So that's all I have in the way of prepared comments. But again, if you all have any questions, I will caution you that this isn't an attorney-client privileged session because we have lots of different companies represented here. But so do be careful if you have a specific situation. Try to disguise it a little bit and not provide individually identifiable information. But with that caution, I'd be happy to answer any questions you may have.
I think we answered all the questions that came in today. If anyone does have any additional questions, please go ahead. You can email me at